Right. Good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the statewide training initiative with Florida Legal Services. We're excited to have you join us here today for the legal impact of House Bill 1365, Navigating Florida's New Camping Law. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded. You're going to receive a copy of the recording in an email from Zoom within 24 hours. If you don't see that email, I'm also going to drop my email in the chat just in case. Feel free to reach out to me if you need anything. The training was approved by the Florida Bar for one General CLE Credit. I'll announce the CLE code at the end of the session. I will also drop it into the chat and it will be included in that email from Zoom with the recording. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly. The training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I'm going to encourage you to take a look at their website. I'm going to drop that link into the chat. And final piece of housekeeping announcements are questions and answers. If you have any questions during the presentation, feel free to drop them into the Q&A feature, or you can also drop it into the chat. If for whatever reason we missed your question, or if it's an unrelated topic, we'll do our best to address your questions towards the end. So with that last housekeeping item, I'm gonna go ahead and introduce our two amazing speakers. I'm gonna start with Daniel Marshall. Daniel joined Southern Legal Counsel in 2022. He is a civil rights attorney who has focused his legal career advocating for criminal justice reform and its impact on prisoners, their families, and the community. He has litigated numerous criminal, federal civil rights, and state public records cases, including dozens of jury trials. He also has lectured on numerous issues, including prisoners' civil rights, Florida's stand your ground law, medical marijuana, and issues concerning the elderly and criminal law, as well as giving presentations in a number of schools in the community. After earning his Juris Doctor degree from the University of Connecticut School of Law, Dan worked at the Office of the Public Defender in West Palm Beach, Florida for nearly 9 years handling felonies, misdemeanors, juvenile delinquency, and appellate cases. After leaving the Public Defender's Office, Dan has worked at several organizations focusing on criminal defense and civil rights litigation. Dan is admitted to practice in all Florida state courts, as well as the U.S. Supreme Court, the U.S. District Courts for the Northern, Middle, and Southern Districts of Florida, the Eastern District of Michigan, the District of New Mexico, and the District of Columbia. In a prior life, Dan worked as a spacecraft engineer in the Goddard Space Flight Center in Greenbelt, Maryland, as part of the team that controlled one of NASA's science satellites. He graduated cum laude from Colgate University with a bachelor's in physics and astronomy. Our other speaker is Chelsea Dunn. Chelsea joined Southern Legal Counsel as an attorney in 2018 and previously served as a director of Decriminalizing Poverty Project, leading SLC's efforts to end criminalization of poverty by challenging governmental laws and policies aimed at arresting rather than housing people experiencing homelessness. Prior to this, she helped establish Southern Legal Counsel's Healthy Kids Medical Legal Partnership with UF Health, which seeks to resolve the health harming legal needs of some of Florida's unserved children. She also litigates cases involving the rights of persons with disabilities and special education cases. I'm going to drop the link to the bio in the materials folder that I'm going to share with all of you. They have really impressive bios. So without further ado, I'm going to pass it over to Daniel and Chelsea. The floor is yours.
Thank you, Jorge, for the great introduction. And welcome everybody to our discussion of Florida's new camping law and some related issues. As Jorge said, we are Chelsea Dunn and Dan Marshall. We are with Southern Legal Counsel. For those of you who don't know, we are a nonprofit civil rights organization based in Gainesville. We do cases all around Florida and many different issues, but pertinent to today. One of the big things we do is advocacy and litigation on behalf of homeless people, and what we call decriminalizing poverty and the things that homeless people need to do to survive, basically. So today we're going to be talking about a few different things. First, before we get into the changes that arrived in 2024 and Florida's camping law, we're going to start out with what the law was and the lay of the land was before that, and kind of the rules that government was operating under before 2024. Then we're going to talk about the two big things that happened last year when the Supreme Court decided a very important case about homeless rights, of Grants Pass versus Johnson. We'll talk about the impact of that. And then obviously the main thing that we're here for today is Florida's new camping law that was passed by the legislature last year. And then we're going to also talk about a couple of other related issues that pop up in this area. Talk about use of trespass laws to arrest and remove homeless people from the public areas. And then also the way that cities and other municipalities go about seizing, and when they go what they call cleaning areas and end up taking the property of homeless people and seizing and destroying those things. And then we're going to talk a little bit about what comes next and where we go from here. So go ahead, Chelsea, take it away.
Thank you, Dan, and thanks, Jorge. Hi, everyone. I'm Chelsea Dunn. So we're going to start by going over or talking a little bit about some notable cases that happened before 2024 and before Grants Pass, including Martin v. Boise, which was the case upon which Grants Pass, Johnson v. Grants Pass built. So in 2019, the Ninth Circuit issued a decision in Martin v. Boise. This decision held that an ordinance which made it a crime to sleep or camp outside was a violation of the Eighth Amendment if it was being enforced when there was not shelter available. So the legal theory is that the Eighth Amendment protects against cruel and unusual punishment. And in the context of a camping ordinance and other sorts of laws that target or punish status, the Eighth Amendment doesn't let. There's a Supreme Court case about being a habitual addict, which the Supreme Court held that the Eighth Amendment does not allow a status to be a crime. It has to, a crime can only be an act. It can't be something that you are. And so the rationale behind this line of this legal theory was that if there's not enough shelter outside, people have no choice. People who are unhoused have no choice but to sleep outside. So if there's not shelter beds for those people, a city or local government cannot, or state government cannot arrest them for the act of sleeping. And this case was a huge victory for advocates that were fighting against the criminalization of life-sustaining conduct, such as sleeping or camping outdoors across the country. Here in Florida, we decided to, oh, Dan, can you move to the next? Thanks. Here in Florida, we decided to pursue this legal theory to challenge an ordinance in the city of Ocala. So the ordinance that we are challenging made it a crime to sleep outdoors if you had, quote, an indicia of lodging, if there was an indicia of lodging available. Indicia of lodging included things like having a tent, being near a campfire, being under a blanket, or on top of, quote, materials. Materials included newspapers or cardboard boxes. What made this ordinance really egregious, though, is that on top of these listed indicia of lodging, telling a police officer that you were homeless was considered indicia of lodging. So as a practical matter, what that meant for enforcement is that someone who was housed could not be arrested for the same conduct as someone who was not housed. If someone who was housed was sleeping outside and when they woke up, the police officer asked, "Where's your address?" and they responded with an address, or "Where do you live?" They responded with an address. They would not be able to be arrested because if there was no indicia of lodging, they hadn't violated the ordinance. But someone who did not have a residence could be arrested under the ordinance. And so we challenge this ordinance on Eighth Amendment grounds, as well as substantive due process grounds. The other kind of factual issue that made this law problematic was that the only shelter in Ocala for single men and women did not have enough shelter beds to accommodate the entire unhoused population. We prevailed at summary judgment on the Eighth Amendment issue. Thanks, Dan. And here in this slide, you can see a picture of our plaintiff, our lead plaintiff, Pat McCardle, holding the decision a few days after it was issued. So the court found that the city's enforcement of the open lodging ordinance was in violation of the 8th Amendment because the officers were not required to make any sort of inquiry into whether shelter was available at the time of the arrest. So the court enjoined the city from continuing to enforce the ordinance until an inquiry about the availability of shelter was made. You can go on, Dan.
Okay.
Unfortunately, then came Grant's Pass. So go ahead, Dan. Sorry.
Right. So unfortunately now we hit 2024, and so the U.S. Supreme Court stepped in, and as Chelsea mentioned, there was the City of Boise case out of the Ninth Circuit that basically said you can't arrest people for sleeping outside when they have no other place to go. And Grants Pass is in Oregon, so also in the Ninth Circuit. And in that case, the city had an ordinance that said is very similar to the one Chelsea just described in Ocala, where if you were quote unquote camping, which was basically anything where you are outside with indicia of sleeping, if you were laying on anything or had any kind of a fire or anything like that, you fell within definition of camping. And two homeless people brought suit against the city to enjoin enforcement of that ordinance. And based on the city of Boise, the Ninth Circuit ruled in their favor, but then it made its way up to the U.S. Supreme Court. And there, the Supreme Court ruled that arresting and jailing people who are camping in public and have nowhere else to go is not cruel and unusual punishment. And that was based on, at issue there was the case that Chelsea mentioned about you can't criminalize status. You can't criminalize, the argument here was you can't criminalize somebody for the status of being homeless. The Supreme Court did not agree with that. However, it said, no, this isn't, you're not being arrested because you're homeless. You're being arrested because you were sleeping in public. You were doing things in public that basically the result of being homeless, but the Supreme Court found that you're not being arrested under that ordinance for the status of being homeless. So it kind of rolled back the city of Boise, and so the 8th Amendment claim is no longer viable in this situation. However, the Supreme Court also mentioned that there are other constitutional provisions that may apply in these types of situations. It didn't get into what those provisions might be, but there are others that could apply. We have a few listed there: selective enforcement. There are potential substantive or procedural due process issues. The case that back in the 60s that Chelsea mentioned that says you can't arrest somebody because of their status started out as a due process case before the Supreme Court ultimately ruled on it based on the 8th Amendment. And so, those, 14th Amendment due process issues can still be raised, and then also potentially issues under the rarely used, but Justice Thomas has been trying to bring back into a fashion the Privileges and Immunities Clause as well. So there are other arguments that can be made in this area. And there are other cases that deal with some other areas out of the U.S. Supreme Court that basically say you can't criminalize conduct or activities that are normally innocent. And these cases usually get decided based on, overbreadth or vagueness, where it's basically impossible for people to tell, is my conduct falling within what the ordinance is prohibiting or not. And then there are also a few cases in Florida that deal directly with sleeping in public. Now, obviously, these predate Grants Pass, but they make a distinction that would also mean that Grants Pass doesn't necessarily fall and apply to these cases, because these cases held that just simply sleeping in public is normally innocent conduct, and can't be criminalized. And they make a distinction between just sleeping in public and what these ordinances said, quote unquote, was lodging. And so, yeah, at what point sleeping turns into lodging is probably going to be a very fact-based inquiry, depending on the situation. But there is, arguments to be made that the grants pass obviously was dealing with a lodging type ordinance, and that just simply the act of sleeping is still activity that can't be criminalized based on this Florida precedent. Okay, so I will pass it off back to you, Chelsea.
Thanks, Dan. Also in 2024, Florida passed a law which was then House Bill 1365. It's now been codified at section 125.0231. It's a law about public camping and sleeping. And it essentially prohibits local governments from authorizing or allowing any person to, quote, regularly engage in public camping or sleeping. The definition of public camping or sleeping is pretty expansive, and it includes lodging or residing overnight in any outdoor public space, even without a tent or other temporary shelter. There's been no court decision yet kind of analyzing what this means, but it could potentially include just sleeping outside, which, as Dan mentioned, is potentially a due process issue. The other thing that is a little unclear is what is regularly sleeping outside. There's not any definition in the statute of how frequently or how often someone needs to be sleeping outside for it to be considered, quote, regularly under the law. Dan, you can go to the next slide. The other thing that House Bill 1365, excuse me, allows for is the creation by a county of a designated campsite, essentially. So property owned by the county can be used for a time of less than a year for people to sleep or camp outside. You can go to the next slide. There are rules, very onerous requirements that apply if a county decides to create a designated campsite, which include that the location of that campsite can't affect property values, and the county has to provide security, sanitation, and access to mental health and substance abuse treatment. It also can't allow drug or alcohol use at the campsite. In addition, so DCF has to actually review the plan for the campsite and certify a county's designation. And that certification is essentially a check that it has complied with these statutory requirements. However, any county that's, quote, fiscally constrained is exempted from these safety, sanitation, and treatment requirements. I could only find a list of Florida counties that are financially constrained that dates to 2023, but it was about half of them. So technically, there are about half of Florida's counties could create a designated campsite and not be required to comply with those safety, sanitation, and treatment requirements. Next slide. The interesting thing about this law is that while the law itself does not make it illegal for a person to sleep outside. What it does is it places affirmative obligations on the government to prevent someone from, regular camping or sleeping in public. The only enforcement mechanism in the law is a private right of action. So there's a provision that gives any resident of the county or business owner in the county the right to bring an action, or the attorney general, of course, the right to bring a lawsuit against the county or a city within the county for failing to prevent people from regularly sleeping outside. So this means that anyone can sue, and if they do and they prevail, they can also recover attorney's fees and costs if they win. So we anticipated, and what we're seeing is that this provision, this private right of action, is pretty coercive. It's led to many cities really revitalizing their efforts to criminalize the act of sleeping or camping outside. Next slide.
So, as Chelsea just mentioned, one of the possibilities is under the laws for counties and just counties, cities themselves don't have the authority to do it. It has to be a county. You can create designated encampments. A couple of things. First of all, as Chelsea just went through the requirements there, but first of all, what county is going to try and find a place, or is going to be able to find a reasonable place to put an encampment that is not going to affect anybody's property value? Also the county's having to pay a whole bunch of money for security and those kinds of things, for the ones that aren't exempt, at least. There are some pretty onerous reasons why the counties aren't necessarily going to do this. But even if they did, they would then also have to comply with the other just general laws that apply to the government. They have to, make sure they comply with the Americans with Disabilities Act, comply with the Fair Housing Act. So they can't create campsites that are segregated or have restrictions based on race. They can't isolate individuals with disabilities. There's environmental discrimination issues. So on top of all the requirements that are in the statute itself, there are other restrictions that would apply to any county created encampment that just would even further means that the counties are unlikely to create these things. So not surprisingly, so far, no county has created a designated camping area. And as far as we're aware, no county is seriously considering doing so. Some cities have passed anti-camping ordinances that are similar to the state law. As Chelsea said, there are no, the state statute itself does not make camping criminal. There's no penalty, criminal penalty for it in the state statute. And so there's no basis to arrest somebody just based on the state statute. However, cities and counties are passing ordinances that criminalize these things and then provide the basis for arresting homeless individuals on this basis, even though the state law does not require the counties and cities to implement the law in that manner. And one of the things our organization does is we're advocating and telling these cities that there are better ways to implement this law rather than just going out and arresting homeless people. And then there are other cities and counties that also already had some older laws in effect that essentially criminalized camping in public as well. And we're seeing that those ordinances are being enforced more strenuously now that the state law has passed.
So I think there was a question that came through about state funding. So the question was, there was no state funding for encampments, right? And to my knowledge, the law did not come with any funding for local governments to use to implement its provisions, including for campsites. So we wanted to also touch on some other issues that arise. So what we anticipate is that as local governments are beginning or continuing to implement this new state law and figure out how to avoid these lawsuits by citizens, that they will be using other sorts of exclusionary practices to try to keep individuals experiencing homelessness out of public space or public view. And so we have, in many occasions, been involved in advocating around legal issues around the use of trespass to exclude people from public space. Dan, if you can, next slide. So every person has a liberty interest in being present in public space. But if you abuse your right to be there by violating the law, violating regulations, violating park rules, etc. A city can ban a person from being on public property, and they do that by issuing a trespass warning. A trespass warning is not a criminal violation. What a trespass warning does is it puts the person on notice that if they return to a certain property, they can be subject to arrest. And so people can be trespassed from private property at the request of an owner. But if property is public, because a person has a right to be in public space, someone can only be trespassed from public property if they are, or if the government who owns the property provides due process. Due process under the 14th Amendment procedural due process affords a person the right to notice and a means to challenge a decision, the decision of being trespassed. So you have to have the right to appeal it, and you have to be informed of some way that you have the right to appeal. Next slide. This issue of the procedural due process required to issue trespass warnings was a second issue that we litigated in the McCardle case. And so in that case, trespass warnings were being issued without any formal appeals process, and no one was really given notice that they could appeal it. And the court found it problematic that the city's trespass warnings didn't have any procedural means for a challenge. The city had no written criteria that would guide officials making the decision to trespass in deciding whether or not a trespass was appropriate. The need for these criteria or guidelines and the need for an appeals process was established in an 11th Circuit decision, Catrone versus City of St. Petersburg, which Southern Legal Counsel, I think 14 years ago at this point, litigated with the National Homelessness Law Center. And unlike the 8th Amendment challenge, which have been foreclosed by Johnson v. Grants Pass, these 14th Amendment procedural due process challenges around trespasses in the appeals process are still good law. Despite that, we have been involved in writing demand letters to many local governments across Florida where people are being trespassed without due process. Either there's not an appeals process, there's no defined criteria, or people aren't given sufficient notice of their right to appeal. And we've managed to get many of these policies changed just by using demand letters because the case law is so settled. But we would not be surprised to find out that there are still many places that are not complying with the procedural due process requirements of the 14th Amendment. And without those protections, it becomes much easier to use trespass policies to exclude unhoused community members from public space.
So one of the other issues that comes up a lot with homeless people is, they're out on the street, they have their stuff, property, they have, identification documents, they might have medications, they have their clothes, they have, some of them have some fairly important things with them. And so another issue that comes up is when the cities are going through and sweeping or cleaning the public areas where homeless people are, the homeless people their property is an issue. So you see here a couple of examples from the city of Miami, where we see the before and after pictures of all the property of homeless people there on the before photos, and then the after photos, it's just all gone. And so oftentimes what happens in these places is the cities are just trashing everything, whether valuable or not, whether abandoned or not, it just goes in the trash and as the cities clear these areas. And we'll see here some examples of some of the personal property that homeless people often have. So what happens when these the cities come through and clean these areas? there was a review by the National Homelessness Law Center that looked at a bunch of cities' policies, and many of which are problematic. Homeless people often have jobs. They can't be there with their stuff 100% of the time. And so if the city is coming through and throwing away all this property without giving notice to anybody, the homeless people really have no chance at all to protect their property. And so back in 2017, only 11% of the cities that were surveyed had some requirement that the city provide notice that they were going to go through and sweep these areas. And even the ones that did have policies weren't necessarily following them. So this can become problematic in a bunch of different ways, as you can imagine. 11% of the cities also required storage of property as opposed to just trashing everything. And the ones that did have policies, it was usually for a month to 3 months and somewhere in that neighborhood. The city's trashing the property gives rise to several different potential claims. Obviously, the Fourth Amendment says that people have the right to be secure in their persons, houses, papers, and effects. That applies to homeless people just as much as it does to the rest of us. And that gets applied to local communities through the 14th Amendment. And then there also is obviously the due process requirement of the 14th Amendment, whereby if you're deprived of property, you have to get a notice and an opportunity to challenge, just like Chelsea mentioned earlier. And so SLC has been part of challenging the practices, these sweeps practices in a few different places. So Chelsea, if you want to go ahead and talk about that.
Sure. So the first time that we litigated these issues was a case in Fort Lauderdale, Stone versus City of Fort Lauderdale. Essentially what happened in Stone is that the city officials had authorized the use of large, heavy machinery to go into a very central downtown park in Fort Lauderdale and just wholesale gather up tents and personal property that was physically located in that park and just throw it in dumpsters. As far as we learned in discovery, and this case did predate my time at Southern Legal Counsel, but I know of it from the work I've done there. What was learned during discovery is that there was no attempt really to provide any notice to allow people to secure their belongings or reclaim their belongings after they were seized by the government. And so Southern Legal Counsel filed a case alleging both the Fourth Amendment and 14th Amendment claims. And the case resulted in a settlement that included policy changes, which would protect the property rights of unhoused individuals and others, and monetary damages for plaintiffs for the property that they lost and any emotional distress they suffered as a result. Go to the next slide. The next and more recent case was in Miami, Cooper Levy versus the City of Miami. Miami, the situation in this case was a little different in that it wasn't one big unannounced sweep. What Miami was doing a kind of regular quote cleanups of their of any areas where there were any size of encampment of unhoused people. So if there was a tent or if there was 20 tents, they would do these cleanings. They had what they called a HEAT team, which stood for Homeless Empowerment Action Team, which was comprised of both police officers and homeless outreach workers that would go out in a coordinated effort to these areas and would engage in cleanup attempts, which often resulted in the destruction, the trashing of personal property of unhoused community members. And while the city did have a policy that required them to give notice of these cleanings, these encampment cleanings, those notices were rarely posted. When they would be inaccurate or have the wrong dates. Sometimes they would only post them in, one language, even though they were technically supposed to be posting them in multiple, in Spanish and English. And even though the city, again, the policy provided for the retention and storage of personal property, unless it was contaminated, in practice, the city was storing almost nothing. The logs of property storage, there were maybe 80 pieces of property stored over a 4-year period. And these cleanings were happening almost every day. So in practice, they weren't really storing people's property like the policy anticipated. Our plaintiffs who were subjected to these sweeps lost personal items that had great sentimental or personal value to them, critical medications, identifications, and one even lost a pet. Similar to Stone, we filed 4th and 14th Amendment claims, and were able to settle this case with policy changes, including an agreement to continued monitoring by plaintiffs' counsel and monetary damages for the plaintiffs in the case. So I noticed a question by Peter Sleesman in the chat. I should give a shout out to Peter because he helped litigate the Catrone case that we mentioned. He asked, do you think there could be negligence actions against local governments per 768.28 for injuries to folks housed in these encampments? My answer to that is going to be really vague. I think that it's a great idea and definitely possible, but I think it's such a fact-specific inquiry. It's hard to say for sure. But what I do want to say is that one of the biggest challenges that we faced in Cooper Levy was proving municipal liability. So because there was a good policy, it was really hard to show that the actual practices, which we felt were very pervasive and widespread, it was hard to establish the requirements of municipal liability, which were determined in a case called Monell versus was it Department of Social Services? Anyway, the Monell case, very hard to meet those requirements when you have a policy that's pretty okay, but no one's following it. It can be very hard to reach that standard. So one of the things that we will reference at the end is that in these cases, I do think often state tort law or negligence claims are a good thing to consider. My preference is usually to go to federal court if I can, but as far as the loss of property, that can be addressed through state tort conversion claims, or other sorts of injuries that are suffered could potentially maybe be subject to negligence actions as well.
Yeah, it's tough to use negligence in federal court because under 1983 you need more than just negligence to have a liability on behalf of a municipality. So, but like Chelsea mentioned a few of the other options there, but it can be tough to get anywhere using negligence. Okay, so what comes next? So far, as Chelsea kind of teased at the beginning, we have seen at least one actual lawsuit. There was in Marathon, some residents and business owners filed a lawsuit against the city there because they were saying there were homeless people that the city wasn't doing anything about, and it got dismissed. Once the lawsuit was filed, the city did something about it, went through, swept the area where the homeless people were, and the case got dismissed after that. I'm not aware of it. At the time it was dismissed, I think the attorney's fees were still an open question at that point. I'm not aware that anything actually ultimately happened on that regarding fees, but certainly the residents, business owners, as we mentioned earlier, would have been entitled to attorney's fees if they prevailed. And then there's also rumblings of other lawsuits being filed. There was a demand letter sent to the city of Jacksonville. This one was a little different in that its aim was basically to try and get the city to provide more services for homeless people. And so this demand letter was saying that the city was not following through on its obligation to provide those services. And I know the city of Jacksonville itself is the city government is split between a couple of different factions. Some want to provide services and others don't. So, or at least not as much. And so, there's kind of an internal tension about what's going on there. And we do anticipate certainly more lawsuits of these type being filed. When you open it up to potential lawsuits from business owners and residents. And there's probably very kind of not much downside, and especially if you get attorney's fees. If you win, that will incentivize attorneys to bring these cases as well. So we definitely anticipate more lawsuits of this kind in the future.
So what can we do? We wanted to end on a note, not just that all of this bad stuff has happened. What do we do now? We're hoping to give some positive ideas for how we can still help our unhoused community members advocate and try to make some incremental change. So obviously, some of the laws we touched on, discussions about the unlawful trespass, without an appeal. These are certainly rights that we can help vindicate for our unhoused community members. The 4th and 14th Amendment property rights are so important during these encampment cleanings. One of the things that we as an organization, along with some of our other partners in this fight, Florida Justice Institute, National Homelessness Law Center, and the Southern Poverty Law Center, we've sent letters to some of the cities and counties that we know have been passing or increasing enforcement of camping ordinance in the wake of Grants Pass and House Bill 1365. These letters both argue for more sustainable policy choices, including affordable housing, investment in resources like services, supportive housing, and just a better use of resources than criminalization, which does cost money because putting people into jail costs money. And if cities just divert resources into making housing available or affordable, you can decrease your population of individuals, of people experiencing homelessness without having to arrest anyone. And these letters also advise these communities of some of the other rights that we fear will be trampled upon as cities and counties try to drive individuals experiencing homelessness out of sight. If we were to see these designated encampments arising, I think there are a number of legal challenges that can be raised in that context. Dan referenced some of them. So disability discrimination laws, there may be some claims under fair housing laws. Certainly, if people are being coerced or forced into these encampments under threat of arrest, there's potentially a right to, there are right to travel claims under both the state and federal constitution. So without actually having a designated encampment and without seeing how cities are kind of using those encampments, it's a little bit hard to say what types of claims are available, but there is a universe of advocacy that could be done to lessen the negative impacts of a designated encampment. As I mentioned before, we also are always thinking about if there are state torts like conversion that could be pursued in state court. And then always, or especially after Grants Pass, using the necessity defense and criminal defense, I think, has become even more important. It was specifically highlighted by the opinion as what should be happening if people are arrested for sleeping outside and there's no shelter available. So to the extent, there's difficulty in these municipal court proceedings or county court proceedings where people often just plead out to time served. They never really get the advice of counsel. And so even just educating our unhoused community members about the fact that there might be a viable defense if they're arrested for sleeping outside when they don't have access to shelter is another really important component of advocacy. I also kind of want to touch on what Grants Pass didn't decide. And Dan made reference to this earlier, but Grants Pass was only about the 8th Amendment claim. There are other legal theories that have been pursued against camping and sleeping ordinances. We referenced some of them earlier, right? You can't make it a crime just to sleep because it's vague. You can't criminalize innocent conduct. Then how do people know when they're breaking the law? But there's also, even in cases of laws that make it a crime to camp or lodge outside, There are legal claims that have been pursued based on this idea of state-created danger, which is it's a substantive due process claim, which essentially argues that if the government forces you to not sleep in this context, if the government is requiring that if you are forced to sleep outside and the government says you can't do that with a blanket or a tent or any sort of cover or shelter, and that puts you at risk of injury because of the weather or other the elements, there is a theory that could be a substantive due process violation for state-created danger. They're also, separate from the state-created danger issue, there still is a viable substantive due process claim. And in McCardle, we did have a substantive due process claim against the open lodging ordinance. It survived a motion to dismiss, but we did not argue it at summary judgment, so the court never ruled upon it, other than to find that it survived the motion to dismiss. But that is also like a path that, is being explored. So we're not certain what the path forward looks like, but we know that there's a path. The other thing I want to say is, Dan, you can go to the next slide. We also are interested, so we're doing what we can to track what's happening at a local level by following the news, but that only gets us so far. So we are always happy to know what local communities are doing as they implement this state law. So please feel free to reach out and contact Dan or I if something is happening in your community that you think is a problem, about, as far as how cities are interpreting their obligations under this new law.
And I just want to add one other comment about, grants passed and the necessity of defense, because that's one of the things that the judges raised, and Justice Gorsuch in particular raised, that it just, to me, kind of shows how removed the Supreme Court is from the practical situation here. Because the suggestion is that, you can get arrested under these ordinances, raise a necessity defense, which is an affirmative defense, so it doesn't necessarily negate probable cause. It doesn't mean the arrest was illegal or anything. It's just the defense you can raise afterward to challenge prevent a conviction. And somehow, being arrested, maybe spending a night in jail, being released, raise a necessity defense on that one, then you're out again the next night and you get arrested again, and rinse and repeat. That somehow raising a necessity defense over and over again after the fact is a practical solution to this. It just doesn't seem like the right way of thinking about this issue to me. So it's one of those things where it feels like there's got to be a better solution than that, but that's where the Supreme Court's coming from on this issue. So all right, anything else, Chelsea?
Not for me. I think we can see if
All
there's
right.
any questions.
Yep, so I think we have some time for Q&A.
Yes, if there's any, I know one of the questions I already marked them as answered. One question I believe was kind of answered. I'm gonna read it out loud anyway because it was asked. Do you think there could be negligence actions against local governments per 76828 for injuries to folks housed in these encampments?
Yeah, I think we already hit on that one.
There's a comment on here, like we have been seeing an increased number of sweeps here at our shelter. They're being shuffled out of the woods surrounding us. Some trespasses have been issued. We have had quite a few guests who have lost important documents or family heirlooms, etc. Don't see any. I did drop both Daniel and Chelsea's contact information into the chat. I also included their contact information in the materials folder where you're going to find a copy of these slides as well. As both of them mentioned, make sure to reach out to them if you see this happening. The way I connected with Chelsea was, I guess, through emails with the Housing Umbrella Group. So if you are a civil legal aid attorney that does some sort of housing work at all, you should definitely be part of the Housing Umbrella Group. If you're not in it and you want to join, send me an email and I'll provide you the instructions on how to join and how to communicate with the listserv because this is one of the challenges that we see, right? We want to kind of keep an eye on what's happening across the state, how this is being enforced, and what remedies are available for the clients that we serve. So I don't see any other questions, or I did see somebody raise their hand. I don't know if that was inadvertent, but happy to, if anybody wants to ask questions. I don't see any. So with that said, I'm gonna go ahead and drop the materials link one more time, and I'm gonna get the CLE code for everybody. The CLE code is 2503750N. I'm gonna drop it here into the chat as well. The CLE code is going to be included in the email that you're going to see from Zoom. I will include it on the YouTube description as well with the link to the materials. So since we don't have any other questions, Chelsea and Daniel, any closing statements, any last remarks before we wrap up?
I think just thank you all for joining, for being concerned about your community members who are experiencing homelessness or poverty. And again, we are always happy to talk through issues or partner with local organizations to help address some of these harms. So feel free to reach out to us if you're seeing it in your community. Oh,
I do see one more question maybe in the Q&A. I don't see it. Mike, I believe you may have a question. I know you already had posted one. I believe it was answered during the presentation. So
I actually don't think we touched on mics. I'm happy to read it.
oh, then I'll read it out loud because it was my bad. I marked it as answered. So, the term of art I'm hearing officials use against unhoused populations is shelter resistant as the precursor to arrest. How can that be determined? Is there no if there's no suitable or available shelter to begin with?
Yeah, so I haven't seen shelter resistant be included as like a criteria for arrest under any of the ordinances we've been tracking. To me, the most problematic, the main use of shelter resistant that's so problematic is it's used kind of in policy or in framing when people talk about these issues in ways that are really harmful or are perpetuating harmful narratives about individuals experiencing homelessness. I think, what I always try to remind people in these discussions is what it's like. Not only are there actually shelter beds that are open and available? In many places, the answer to that is no. But even when there are, I always urge people to think about what that means to enter a shelter for someone. So for many people who've been living on the streets for a long time, entering a shelter requires them to give up a significant amount of their possessions. If they have pets, they have to give up their pets. If they have a partner, most shelters are single sex, divided. And so if they have a partner that they've been close with or living with, they have to separate from that partner. The people, when they go into shelters, are asked to do things that we wouldn't tolerate in our own lives. And so I think that's always something to remind people about. The other issue is that congregate shelters are often not appropriate for people who are experiencing mental illness or have other sorts of disabilities. Being in a shelter can increase anxiety, paranoia, fears of having, belongings stolen. It can exacerbate trauma that's already been that has been experienced on the streets. So, when I hear people say shelter resistant, usually my response is to try to contextualize that and explain that the person may not be resistant to having a home. They may be resistant to having a shelter or having to go to a shelter because of the conditions in those places. They're not really suitable. Many shelters can be a very good short-term solution, but they can also be very difficult for people to enter and to stay in for extended periods of time.
All right, so I see a lot of thank yous, and I have to kind of echo all those sentiments. Thank you for joining us today, Chelsea and Dan. Amazing presentation, very much needed, and thank you everybody else for joining us. I don't see any further questions, so be on the lookout for that email. The recording will be posted on YouTube. So thank you all again. Have a great rest of your day.
Jorge, thanks everyone.
Thank you.